Welcome to the webinar, and we just have a few housekeeping items before we get started, but I'd like to introduce myself. I'm Laura Arrington. I coordinate the New York State Parent Center as well as the Federal Parent Center. And we have with us today George Gray, who will give a great introduction of himself in just a few minutes, but we're anxious to have him here and learn a lot of information from him today. Just a few little housekeeping notes. I'm going to show you how to use the questions pane. We'd like to save questions till the end, but if you have a question, we'd be happy to answer them, and I'll show you how to use that. There'll also be a follow-up email with SurveyMonkey and a link to any handouts, as well as the PowerPoint in that. So if you're seeing your screen right now, there is a little arrow up at the top. So you can, if this is in your way, you can click on the arrow and you can collapse that, and then you won't have to see that any longer. So that's helpful. So you can see it when it looks big. If you're having problems joining us and you're not hearing us, there is always the option. You can click on the audio and it will come up use mic, and it will give you or a phone number, and you can call in and be able to listen to the webinar as well if you're having some trouble. So you can see that there to join the conference if you want to use your telephone. We have a couple of polling questions that we'd like to ask. We'd just like to kind of get to know who our audience is. So I'm going to set that up. So we kind of like to know who is joining us today. And we're going to show that. And so what we're asking is if you're a parent, an individual with a disability, an education professional, human service provider. I'm just going to take a minute to let everyone have an opportunity to answer that. And it looks like we're at about 95% of the people have voted. And I'll just give it one more minute in case anyone wants to let us know who they are. Okay, I'm going to close that, and I'd like to share the results with you so we can all see that. So it looks like 61% are a parent or a family member, and 39% are a human service provider. So thank you for providing us with that information. And the next thing we'd like to ask is we're looking to see the age of either the family member or the person that you serve is. We have 0 to 17. 18 to 40, or over 40 years of age. And we're just going to give it another minute or so to let people finish. Okay, we're almost there. Just a few more people, allow a few more people to vote if you feel comfortable with sharing with us that information. And I want to share that information with you now. And it looks about 44% have someone between the ages of birth to 17, and 56% 18 to 40, and 19% over 40 years of age. So thank you so much for sharing that. The next question just helps us get a little more information, because I believe the information that George is sharing with us and has shared with us throughout these is do you live in New York State? Because I believe this is all going to be very New York State specific. And well, that looks like it was very easy to understand, because it looks like 100% of everyone has a family is in New York State, so that's great information. And just our last poll is just asking if you are familiar with what OPWDD, which is the Office for People with Developmental Disabilities, is, and if you're familiar with it. And we're just waiting for everyone to vote. And you have yes, no, or I'm not familiar, and that's okay as well. It just provides us with a little more information. And I'll just give it another moment for everyone to finish. Okay, I'm going to close the poll so we can take a look. And it looks like 88% say yes, 6% said no, and an additional 6% said that they're not familiar with OPWDD services. And again, that's something that Starbridge may be able to help you with. So if you have questions at the end, there'll be our number. So if you have questions about OPWDD services, you can feel free to call in. Next, I'm going to start to hand it over to George Gray, who is going to talk to you about ABLE accounts. So let me just switch over to make George be able to share his great and wonderful information with you.
My name is George Gray. I am a member of Starbridge Board of Directors since 1990. I've been in practice in Rochester for over 39 years. My practice areas include wills, trusts, and estates, as well as counseling families with a loved one with a disability. I'm spending more and more time in that area as my practice develops and I move into an area that I really enjoy, which is assisting families with an individual with a disability. I have extensive experience with creation and administration of supplemental needs trusts and 17A guardianships. Those of you who may be familiar with the previous webinars, I did a two-part webinar on 17A guardianships 2 weeks ago and 4 weeks ago, and that's available on the Starbridge website. I do a lot of work with supplemental needs trusts, and I'm counsel to a local bank that's the trustee of supplemental needs trusts. So I know about the not only the establishment of the trust, but also the implementation and administration of the trust. I wrote a book in 2014 called Special Needs Planning: The Simple Guides for Families in New York with a Loved One with a Disability, and it talks specifically about individuals with a disability and the response from their family members. There was a period of time when a lot of advocates for persons with a disability were lobbying Congress for a savings vehicle that would allow the individual with a disability to save money that would be in excess of the $2,000 resource limitation for supplemental security income, and would not affect their eligibility for supplemental security income or Medicaid. That was culminated in a legislation that was passed in 2014, December 19th, called the ABLE Act. As I said before, the ABLE Act stands for Achieving Better Life Experience, and what it did, the federal legislation, what it did was it enacted a section of the Internal Revenue Code, Section 529A. I'm sorry. 529 is a section of the Internal Revenue Code that allows for individuals to put money into an account for the benefit of other individuals going to college or for their education. That's a 529 plan, and there's one in New York and all the other states. Section 529A has to do with ABLE accounts, and it allows for a savings account, a vehicle that would store money for an individual with a disability without affecting their eligibility for means-tested government benefits. In December 2015, New York State passed some enabling legislation. Let's back up for a second. The federal legislation, all it did was set the parameters, the general gross outline of an ABLE account as a 529A account, and it said that in order for a 529A account, an ABLE account, to come into existence, each of the states had to adopt legislation which enabled the ABLE account. New York did that in December of 2015, and the name of the act is called the New York ABLE Act. Under the New York ABLE Act, the legislation itself says that it became effective on April 1st, 2016. So we have ABLE accounts in New York as of April 1st, 2016, but they're still not available because there is re regulations that have to be adopted by the Office of the State Comptroller, who's currently working on the launch of this program and anticipates that earliest it'll be available is the end of 2016. So what I'm giving you is the latest of what's available on the description of an ABLE account. The important part of an ABLE account that most people want to know about is how do they set one up and who do they set it up with. That information is not yet available. It's coming from the Office of the State Comptroller, and that's the agency in New York that's responsible for dealing with ABLE accounts. The reason why the State Comptroller is involved with it is because the Comptroller of the State of New York regulates the banks. And this ABLE account is going to be a bank account offered by a financial institution of some sort to allow for the individual with a disability to save. The Office of the Comptroller is working on regulations in consultation with the Office of People with Developmental Disabilities, the Office of Mental Health, and the Department of Health. What that tells you is that so much of the ABLE account affects Medicaid and SSI that we want agencies that are dealing with those benefits to have input into how it's going to work. Pam Merkel received an email from some members of the audience that I think it's appropriate to answer the questions now because it relates to the setup of an ABLE account. And one of the questions was, New York ABLE account does not have a start date. While we wait, we would like to evaluate the legislation to compare the existing first-party pool trust offered by New York by not-for-profit agencies. There is no regulations that give you the exact parameters of how to set up an ABLE account and where to set it up. What we do have is we have the legislation that talks about the parameters of an ABLE account, and one of the things that would be helpful to an individual that was interested at this time to get more information about ABLE accounts and what they can and can't do is to get the proposed regulations of the IRS. They are set forth in the Internal Revenue Bulletin 2015-27, and the website for that is www.irs.gov/IRB/2015-27. You can also Google IRB 2015-27, and that should get you to the same place. What that will do is give you the proposed regulations that were prepared by the Internal Revenue Service about what an ABLE account will and won't do. The next question is, could we get references to the legislative bill and outline a proposed administrative program? I can give you the website for the New York State statute, which enables ABLE acts in New York, and that you can get by Googling New York State Senate bill, and then here's the bill number, S4472D. So if you Google New York State Senate bill S4472D, that should get you to the text of the bill. Let me tell you that the text of the bill is less enlightening than the proposed regulations, and neither one of them really tell us how and when and who we need to contact to set up an ABLE account. The next question I have is, will the DSS be required to accept New York ABLE accounts? My understanding is that a New York State will be required to accept an ABLE account. ABLE accounts are going to be authorized by New York State statute, and as such, are not counted as a resource for purposes of SSI when you're dealing with the Social Security Administration, and for purposes of Medicaid when you're dealing with the New York State Department of Social Services. How long will it take for Monroe County to adopt it? It's not a matter of Monroe County adopting it. It's a matter of the New York State Comptroller contacting private purveyors of ABLE accounts and getting them to be offered to New York State residents. Once that happens, I would assume that in the annual certification process, you would reveal the existence of an ABLE account and identify it as an ABLE account to the Department of Social Services. Can a Monroe County reject an Ohio ABLE account? That I'm not sure. I don't believe that they will be able to, because an ABLE account is one that's authorized by state and federal legislation, and Ohio has authorized it. There's no residency requirement for enrolling in an ABLE account, so my suspicion is that New York State should accept an Ohio ABLE account. Would a beneficiary be able to move from a pooled first-party trust to an Ohio ABLE account to a New York ABLE account? I think the thing to do there is to look at to contact the administrator of the pooled supplemental needs trust to see whether or not they will authorize a distribution to an Ohio ABLE account. I believe that the legislation, although I didn't look at this question specifically, but the legislation does allow for transfer from one state to another for ABLE accounts. So it would be possible. But the first place to look is to ask the administrator of the pooled supplemental needs trust to determine if they will make a distribution out to an ABLE account. I am of the opinion that supplemental needs trustees, including a first-party supplemental, individually trustee supplemental needs trust, should be able to fund an ABLE account. The reason why you might want to do that is because first-party supplemental needs trusts are for the sole benefit of an individual, and there's a narrow definition of what are available in allowable distributions from a first-party supplemental needs trust. There is some indication, although it's not definitive, that the distributions from an ABLE account will be a little bit more liberal, and that an individual might benefit from transferring money from an individually trustee supplemental needs account trust to an ABLE account. Again, it's too early to give you a definitive answer because we don't know what's happening in practice, and New York is yet to engage in practice. One of the things that we want to talk about is the legislative intent of the ABLE account, because this is informative to give you background and context of how it's set up. The first thing is it's to encourage and assist individuals and families for saving private funds for the purposes of support to maintain health, independence, and the quality of life. So it's going to encourage and assist in savings. This is a savings account. You put money into the account and you take money out as if it were a savings account. So this is going to assist people to do that. The other thing is it's going to provide a secure funding for disability-related expenses of the beneficiaries with disabilities that will supplement but not supplant means-tested government benefits. So what's important to understand here is that you can't spend money that Medicaid is going to provide for. If there's a service or a product that Medicaid is going to provide for the person with a disability, you can't get frustrated with the bureaucracy of Medicaid and just pay for it out of an ABLE account, because it may not be qualified as a qualified disability distribution, and if it's not, then there's adverse consequences to that. So you want to look and see that it's going to provide for other things. Basically, similar to a supplemental needs trust, it's going to enhance and enrich the life of the beneficiary. I talked about the administration in New York of the ABLE program, and the reason why I mention that is because the controller, the office of the controller, has not yet issued regulations. They went out for an RFP to private purveyors of ABLE accounts. The model that's used is the model for a 529 education account, where you go to a private purveyor at Oppenheimer or someplace else, and you put your money in with Oppenheimer, and then Oppenheimer administers the 529 account within the parameters of the statute. But you're dealing with a private purveyor, and it's as if it were a private savings account subject to a lot of rules. So we're still waiting for those rules. One of the other things that's important to understand about the ABLE Act is the fact that it's definition driven. There are somewhat intuitive language that's used in the statute that talks about who's eligible to participate and what are the permissible distributions and the like. But it's important when you deal with ABLE Acts that you pay attention to the definitions. So an understanding of certain key terms is essential to make sense of the use and purposes of ABLE accounts. First thing we're going to talk about is an eligible individual. And who is an eligible individual? It's a person who's eligible for SSDI or SSI, and the outset of his or her disability occurred before the individual attained age 26. For those of you who have family members or persons with a disability who are older than 26, you have to look and prove that the onset of the disability occurred prior to the age of 26. Now, if it's a DD, developmental disability, it's more than likely that it's going to be easy to prove because that's a lifetime disability. But if there are other disabilities which would make you eligible for SSI that are not necessarily result in an onset from childhood, then you have to prove that the disability occurred on before the individual attained age 26. The before attaining age 26 is driven by the budget, because what happens is if they allow for individuals who have a disability that the onset occurred after age 26, let's say to 65, then more people would use ABLE accounts and less tax revenue would be generated. So they chose 26 as a time for limiting the fiscal impact of ABLE accounts. The other way that you can do it is if you're not on SSI or Medicaid, you can get a physician certification that the individual has a permanent disability, and again, the disability occurred before the individual attained age 26. And finally, if you're blind, within the definition of Social Security. So that's who is covered by the ABLE Act. And what's important to understand, and from my perspective, the easiest thing is if you're getting SSI or you're getting Medicaid, you're eligible so long as the onset of the disability occurred prior to age 26. So now we turn to who is a designated beneficiary. That's also a term in the statute. A designated beneficiary is an eligible individual who established an ABLE account and is the owner of the account. So the designated beneficiary is a person who establishes the account and is the owner of the account. And what's important about this is when distributions are made from the ABLE account, they have to be made for the benefit of a designated beneficiary. So if you think about it, the universe, there's a universe that's larger than designated beneficiary of eligible persons, eligible individuals. Somebody could be on SSI or Medicaid but not choose to use an ABLE account. If you choose to use an ABLE account, then you're not only an eligible individual but also a designated beneficiary. So An ABLE account is established under a participating state's program to which a person may make a contribution. We spoke about this earlier. What we're talking about is the fact that the state of New York has passed enabling legislation that's effective as of April 1st, but we don't have the regulations for, that allows for ABLE accounts. This means that as soon as you can get a New York ABLE account, the Department of Social Services and the Social Security Administration should accept and acknowledge that they are an ABLE account. One of the things that's important to understand is, like many things that are involved with the disability community and the eligibility for means-tested government benefits, is that they're driven by rules. And the rules aren't necessarily intuitive. So what's the first thing? Most of these rules that govern an ABLE account is to make it simple. So the first thing is that an ABLE account can only accept contributions in the form of cash, check, money order, credit card, or other similar method of payment. You can't put in property, you can't put in stock, you can't do anything. You got to put in cash or cash equivalent. It can only benefit an eligible individual. So an eligible individual is a person with a disability whose disability started before the age of 26. And it's used for the purposes of meeting qualified disability expenses. And we'll talk about what a qualified disability expense is, and the qualifying disability expense must be for a designated beneficiary. Why do we go through the process of establishing an ABLE account? Remember, an ABLE account is a savings account that allows for an individual who's on SSI, for instance, to put into the bank an amount in excess of $2,000. Many of you who are parents and loved ones of a person with a disability on SSI know about the concern each month that the amount that your loved one has in an individual account doesn't exceed the $2,000 level. For Medicaid purposes, the amount is $14,850. And again, you can put money into an ABLE account, and even if it exceeds the $14,850 level, it's still eligible for Medicaid if you've got an ABLE account. Okay, so an ABLE account is a savings account that is disregarded as a resource, and for certain circumstances disregarded as income for purposes of eligibility for means-tested government benefits. Let's back up for a second and revisit what it means to be means-tested. Means-tested for SSI means that you have to have income of less than $825. You have to have income of less than about $825 a month, and you have to have resources of less than $2,000 in order to be eligible for SSI, to get any SSI. And then for purposes of Medicaid, you have to have similarly income of less than $825, and you have to have resources of less than $14,850. Going back to SSI, there's a clawback of benefits if your income exceeds $20, but the discussion of the income rules for SSI is beyond the scope of this seminar. So just know that you're interested to know what the disregard of the income is for purposes of ABLE accounts. First, we're going to talk about resources. So what it means is that the following amounts are disregarded as an available resource. Any amount, including the earnings in the ABLE account. So once you get the money into the ABLE account, it's disregarded for SSI and Medicaid purposes. Any contributions to the ABLE account, that doesn't count. And any distributions for qualified disability expenses from the ABLE account. So what's important about that is that you have to remember the definition of a qualified disability expense, and we'll get to that. And you always have to make distributions for qualified disability expenses in order for the ABLE account to be disregarded. The rules for income are similar but not the same. For purposes of means-tested government benefits, the following amounts will be disregarded as income to the benefits recipient. Earnings on the amount in the ABLE account. So if the ABLE account's put into, for simple purposes, a CD or a savings account that earns 1% per year, and there's $100 in there, that $1 of interest that was earned for the year is not income to the beneficiary. Any contributions to the ABLE account made by third parties. So if a parent makes a contribution to an ABLE account for the benefit of a child with a disability, that's not counted as income to the child with a disability. And any distributions from a qualified disability expense from the ABLE account is not counted as income. The bad news is, if it's not a qualified disability expense and it's made from the ABLE account, it's determined to be income for purposes of means-tested government benefits and also for the Internal Revenue Service. One of the things that I've discovered is that I had hoped when the legislation came out for an ABLE account that we could use ABLE accounts for spend down. What's a spend down? A spend down is when you, because you earn Social Security disability insurance, or you have a job that allows you to exceed the income limits for Medicaid or SSI, you can put that money into an individually trustee supplemental needs trust, or you can put it into a pooled supplemental needs trust, and it'll be disregarded as income. You're allowed to use that to spend down your income to get underneath the income level. For purposes of Medicaid and SSI, that's not true. If an individual makes in excess of the income limits for SSI or Medicaid, and they put their money into the ABLE account, it's not disregarded as an income. So you will not get the benefit of a spend down if you put your income or your excess SSDI benefits into an ABLE account. This is something that is disappointing to me and to a number of my clients, because they had hoped that an ABLE account would be a simple way to allow for spend down. One of the things you have to remember with pooled supplemental needs trusts is they're inexpensive to set up, but they usually have a monthly fee that's associated with them. So if your spend down is $50 a month and your monthly fee is $25, you're spending $25 to the pooled supplemental needs trust for the benefit of the spend down. Whereas if you spend the money up front to do an individually trustee supplemental needs trust, you get the benefit of the spend down, but you've got the expense of setting up the trust. And the hope was that an ABLE account would allow for an inexpensive way to set up a way to spend down the income. So to repeat myself and to make the point rather pointedly, ABLE accounts are not available as a spend down. One of the things that happened is, and a lot of this stuff is generated for income tax purposes, but there are exceptions to the general rule. So one of the things that's a qualifying disability expense is payment for rent and housing. However, if there is payment for housing, distributions for housing expenses will not be disregarded as income of the designated beneficiary. So if you have an ABLE account and you spend $400 for rent, that income it's considered income for SSI purposes. The other thing is that any amount in excess of $100,000 in an ABLE account will be considered a resource to the designated beneficiary. So that the upshot of that is that the maximum that you can put into an ABLE account and still maintain eligibility for SSI is $100,000. Now that's not going to be a problem in the early years of ABLE accounts, because another rule is that you can't put more than $14,000 a year into an ABLE account. So if you put the maximum in, it still would take you 7 years to reach the $100,000 level. So in the early years of ABLE accounts, it's not going to count. What does it mean if there are excess amounts in an ABLE account? Remember I said that the excess amount is $100,000. First thing is it will, the SSI benefits will not be terminated, but instead will be suspended until the amount in the ABLE account falls below $100,000 threshold. So how would that work? So if there's $100,000 and it exceeds, then you have to spend down the money that's in the ABLE account below $100,000 in order to be eligible for SSI. The other thing is, and again, this is just the rule, it's not necessarily intuitive, is that the $100,000 limit for ABLE account impacts SSI benefits. It does not impact Medicaid benefits. One of the questions that was asked about ABLE accounts was, what happens if my child has a developmental disability and can't establish his or her own ABLE account? Will I be able to do one for my child? And the answer is yes. So what happens is, the first person that can establish an ABLE account for a designated beneficiary is the agent under a power of attorney. So if the person is capable of understanding what a power of attorney is and has capacity, then the person that's serving as their agent, the person to whom they've given the power of attorney, can set it up. Practically, the second one is going to be the most important, which is a parent or legal guardian of a designated beneficiary can set up an ABLE account. So an individual with a developmental disability can set up an ABLE account, and they can do it through their parent or legal guardian. I would assume legal guardian would include a 17A guardian for a developmentally or intellectually disabled individual, and that would allow for somebody to set up the ABLE account easily. The other thing that's important to understand is you're limited to one ABLE account. So if you set up an ABLE account, even if you set it up in Ohio or some other state, and you try to set up another ABLE account, only the first established ABLE account will count. The rest of them will not count. They'll be used as an available resource for SSI and Medicaid purposes, and distributions from them will not be disregarded as income for either Internal Revenue Services or for purposes of means-tested benefits. So you're limited to one account. One of the administrative difficulties about that is, how are we going to monitor the limit of only one account? What happens, for instance, if you have an ABLE account for the benefit of an individual who has very charitably inclined relatives, and the parent sets one up in New York, and the grandparent sets one up in Ohio? That's going to screw up the planning for the individual with a disability, but you are only limited to one ABLE account, and so you've got to pay attention to that. And so the other question is, how is the government going to know there's only one account? The other things that are important to understand is that there are certain administrative features of an ABLE account. The first is that not more than twice a year the designated beneficiary may directly or indirectly, for instance, if you're developmentally disabled, if you have a developmental disability, I should say, and your parents can do it for you. And they can select how the amounts in the ABLE account are invested. That's similar to the investment options that are available under a 529 plan, and that's why it's there. So you're limited to twice a year, but you can adjust the investments that are in the ABLE account. one of the things is this is kind of intuitive, which is no portion of the ABLE account may be used as security for a loan. So you can't go to the bank, pledge the ABLE account, and borrow money from the bank and have that not count. If you do, then the ABLE account is disregarded, is included as an available resource for SSI purposes, and it's ineligible for the other status as an ABLE account. We're going to talk about qualified disability expenses, but one of the things that's important to understand is that there are income tax features of the ABLE account. And this is similar to a 529 plan in another context. But what it means is that any distributions from the ABLE account for qualified disability expenses of the designated beneficiary, those are two defined terms. Qualified disability expenses, we'll talk about a designated beneficiary is a person who's eligible, is an eligible individual, and who has set up an ABLE account. If there are distributions out, they are not income subject to an income tax. So you can make it, a parent, guardian, loved one can put money into an ABLE account, and it's not income to the individual with a disability, and distributions out from the ABLE account for qualified disability expenses are not income for income tax purposes. And here's where the definition of a qualified disability expense comes into play. If it's not a qualified disability expense and it's been made from the ABLE account, then the amount of the distribution itself is subject to an income tax. In addition, it's subject to a 10% penalty tax. So there is some penalty, and you do have to pay attention to what the distributions are. There's another feature of an ABLE account, and that's gift tax. Remember I said that other people can put money into an ABLE account, and the question is that a taxable gift for purposes of the federal statute? They're not considered a transfer subject to a gift tax if they're made by the designated beneficiary, by the individual, him or herself. They're not a transfer subject to gift tax. If they are made by a third party, they are subject to a gift tax, but they're eligible for the annual gift tax exclusion of $14,000. Why is the $14,000 important? Because the maximum you can put into an ABLE account is $14,000 in 2016. The gift tax exclusion goes up each year, and so too does the amount that you can put into an ABLE account, but that's matched each year. So it's impossible to put more money into an ABLE account than what is the gift tax exclusion. Therefore, there will not be a gift tax, and the individual that's making a contribution to the ABLE account will not have to file a gift tax return. So we come back to, for emphasis, limits on the annual contributions to an ABLE account. This is important because what happens is the total annual contributions to an ABLE account by all participating individuals. So if you've got the grandparent in Ohio putting money into an ABLE account in Ohio for the benefit of their grandchild, and the parent's putting money into a New York ABLE account in New York, then the parent and the grandparent have to coordinate to make sure that the amount that goes in does not exceed what's called the annual exclusion amount. The annual exclusion amount is an amount that can be made without the imposition of a gift tax. That changes each year. In 2016, it's $14,000. So what's interesting about that is that the gift tax exclusion for gift tax purposes is exactly the same as the annual limit to an ABLE account. So we tie into that. One of the things that's important to understand is that the eligibility for the annual exclusion amount was not a slam dunk and had to be put specifically into the statute for the exclusion for contributions that are made to ABLE accounts. If that rule was not put into the enabling legislation by the federal government, it would not be eligible for the annual exclusion amount, and there would be gift tax consequences to the contribution. But the statute put language in that said that it was eligible for the annual exclusion amount, and it keyed the amount of the annual contribution to that annual exclusion amount, so that the $14,000 in 2016 is important for two purposes. That may go up in 2017 and going forward, but right now it's $14,000. Remember I said that the amount of money in a ABLE account cannot exceed $100,000 without affecting SSI benefits? Well, New York State has keyed into that to say that the maximum amount you can put into an ABLE account in New York State for a New York State ABLE account is $100,000. So again, that's tied into the federal the SSI regulations, and you can't exceed the $100,000. There are no residency requirements for ABLE accounts. So if you're a person with a disability in New York and you want to go to Ohio or Florida to set up an ABLE account, you can do that. I don't know what impact that will have on this aggregate limit, and that's something that time will give us information about. So the ABLE account is something that's beneficial to the designated beneficiary, but it comes at a price, and the price is that whatever's in the ABLE account at the death of the designated beneficiary, the eligible individual, is subject to a state recovery for medical assistance, i.e. Medicaid, for payments made on behalf of the beneficiary after the date of establishment of the ABLE account. So if you establish the ABLE account in January of 2017 and you make distributions out of it, and then you die, the amount that's in there would be subject to recovery, Medicaid recovery, for all amounts paid by the state after January 1st, 2017, when the account was established. What I want to do is I want to contrast that with the payback provisions for a first-party supplemental needs trust, which requires reimbursement for all amounts paid for the beneficiary, even amounts paid prior to the establishment of the first-party supplemental needs trust. So like the first-party supplemental needs trust, there is a payback, but it's only for amounts after the date that the account was established. Now we come to the part that I think is most interesting to most people, which is qualified disability expenses. So we think, based upon some of the regulations and based upon some language that's in the regulation, that amounts that can be paid out of an ABLE account will be a little bit more expansive than distributions from a first-party supplemental needs trust. But that's not certain, and we'll have to wait for time to tell. What a qualified disability expense, it means that any expense related to the eligible individual's blindness or disability, which are made for the benefit of the eligible individual who is a designated beneficiary. So you have to be an eligible individual, you have to establish an ABLE account, and then the distribution has to go out for your benefit. One ABLE account, one designated beneficiary. And what it's going to do is it's going to maintain and improve the designated beneficiary's health, independence, and quality of life. So that's kind of the general rule. What's important is the Treasury regulations, and remember I spoke to you early on about the website that will get you to Internal Revenue Bulletin 2015-27. That has the proposed regulations, and in the proposed regulations they have examples of qualified disability expenses. So they include expenses for education, housing, transportation, employment training and support, assistive technologies, and personal support services. One of the things to remember is that if the ABLE account makes a distribution for housing, that's going to affect the designated beneficiary's eligibility for SSI. Other qualified disability expenses include health, prevention, and wellness, financial management and administrative services, legal fees, expenses for oversight and monitoring, and funeral and burial expenses. So I think one of the things that's going to happen is there's going to be some analysis of an ABLE account versus a pooled supplemental needs trust. And we're going to look at what an ABLE account can be used for in terms of distributions, and going to compare that to the somewhat rigid rules that pooled supplemental needs trust sometimes impose upon distributions. So an ABLE account may be something available that's in competition, if you will, with a pooled supplemental needs trust. The other thing is we don't know, but we suspect that the expenses and the monthly fees will be less for an ABLE account than they will for a pooled supplemental needs trust. But again, we don't know the answer to that question. This is important, and this is what I base a lot of my advice to clients about. The Treasury Department and the IRS have concluded, and that's part of the regulations that I spoke about, that the term qualified disability expense should be broadly construed for two purposes. First, so that it will permit inclusion of basic living expenses. It should not be limited to expenses for items which there is a medical necessity. So you don't have to prove a medical necessity for the distribution. It just has to be for basic living expenses. And the other thing is that if you make a distribution for purposes of a first-party supplemental needs trust, it has to be for the sole benefit of the individual with a disability. Sole benefit means that nobody else can benefit from it. And what we've got here is we've got language that says that you can make a distribution out, and it's not limited to distributions which provide no benefits to others in addition to the benefit of the eligible individual. So the example, and the one that I always use, is the television. Okay, an ABLE account can pay for a television, even if it's in the living room of an apartment with a person with a disability, and he or she has roommates. It would benefit other people, but it would be for basic living expenses of the individual with a disability. So it's possible that it could be a qualified disability distribution. So we're interested to see how this liberal construction will apply. There are restrictions on qualified disability expenses. And what I mean by that is that the distribution has to be made for the benefit of a designated beneficiary at the time he or she has a disability. So obviously an individual with a developmental disability, an intellectual disability, a blindness isn't going to go in and out of that disability characterization. But there might be other types of disability where the individual could have an ABLE account but not classified as a person with a disability for Medicaid or SSI purposes. If that happens, then the ABLE account cannot make distributions, because if they do, they'll be subject to an income tax. With that, I'm going to stop, and I'm going to take questions. One of the things that I want to let you know is that a lot of the questions that you have, or I anticipate that you have, will not be answered until the end of the year. But if you do have questions, I'd be happy to try to field them right now.
Great, thank you, George. We actually have several questions that have come in. So the first question I have is, can an individual have both a supplemental needs trust and an ABLE account?
Yes. They're cumulative. So in fact, I would I would ex I would expect that an individual could have a supplemental needs trust. They duplicate one another to some extent, but one of the questions is going to be, let's assume that we find out that there can be distributions from an ABLE account which are broader than the distributions that can be made from a supplemental needs trust. You might set up an ABLE account for that. The other thing is remember that an ABLE account has a limit of $14,000 that in any particular year. So let's take a situation where an individual has an inheritance that's made directly to that individual from a grandparent, and the amount exceeds $14,000. They can't put it into, they can put up to $14,000 into an ABLE account, but the excess amount has got to go into a first-party supplemental needs trust in order to maintain eligibility for Medicaid and SSI. And the other thing that's important to remember is that first-party supplemental needs trusts don't have a limit, an upper limit on the amount that can be in there. So if you've got a personal injury award, you're obviously going to use a first-party supplemental needs trust because, first of all, the amount that comes to the person from a personal injury award is probably going to exceed $14,000, and more than likely, in a catastrophic situation, it's going to exceed $100,000. So you can't have both.
Okay, we have another question. Would the 17A guardianship require a property guardianship in order to establish an ABLE account?
Don't know the answer to that.
Okay. We have another one. Can a grandparent actually set up an ABLE account? They said it was my understanding that it's only parent, legal guardian, or the individual or their POA.
That's correct. So you'd have to have a parent, a guardian, the POA, or the individual, him or herself. The grandparent can put money into the ABLE account, but only the parent, the guardian, or the POA can establish it.
Okay, great.
That's a good question because I really hadn't thought through that iteration, so that's a good question.
We have another one. Can resources in an ABLE account be used for burial expenses after the individual has passed away?
Not after the person has passed away. What happens is you look at the qualified disability expenses for the individual prior to the date of death, and whatever those are gets subtracted from what is the Medicaid payback. You can use an ABLE account to do a prepaid burial trust or something like that. So my recommendation, and strong recommendation, would be basically to set up a prepaid burial expense because if the person dies and then you want to pay the expense, you can't out of an ABLE account.
Okay, great. We have a question from Carrie. It says, where will the finalized information regarding allowable distributions be available when it's completed?
They are complete. That what we have is what we're going to get. You're going to be dealing with, as is the case in many stuff with SSI and with Medicaid, you're going to deal with just what the regulations have said. I believe that if there's further explanation for SSI purposes, it'll come out in what's called a Program Operations Manual System, POMS, P-O-M-S. And there's already one POMS that basically says that if an individual makes a, excuse me, if an individual makes a contribution to an ABLE account of his or her own money, that's still counted as income for purposes of SSI. So we do have one POMS that does give us some example of what it would be, but in terms of the distributions, the regulations, the Treasury regulations have a list, and there might be some information that will come out when you deal with a private purveyor of an ABLE account. They might have some further explanation for it. But we're really not going to, I don't see the state or federal government giving any more direction than what they've already have.
Okay. I have another one from Margaret. It says, George, have you ever done a POA for an individual with an intellectual or developmental disability? If so, who or do you determine their capacity?
Well, the the ability to do a POA depends upon capacity. Capacity has to do with an individual ability to understand the parameters of a power of attorney, the grant of powers under the power of attorney, and the impact of the power of attorney. I've never done one for somebody that has, if they have a designation of intellectual or developmental disability, then probably they can't do a power of attorney because they'll lack the very essence of an individual with a developmental or intellectual disability is they lack capacity. If there's no determination, then you probably, if you've got a concern about the individual, you probably would think about having a doctor say that they do have the capacity because it could be challenged.
Okay, great.
One other point on
Mm-hmm.
that. If somebody gets a 17A guardianship for an individual, you can still, the individual can still, and this is in my previous webinar, can still get, under certain circumstances, a healthcare proxy for an individual with an intellectual or developmental or intellectual disability, provided that they're competent. And competence is a little bit different than having capacity. So it's possible for somebody to have a 17A guardianship and a healthcare proxy, but probably not needed. It's not possible for somebody to have a 17A guardianship and a power of attorney because there's been a determination that's made that the person lacks capacity.
Okay. I have another question. It says, if a minor child lives with a parent, is a housing rent payment not allowed?
That would depend upon the rules of Medicaid and SSI, and I don't know those rules, that particular aspect of the rules that well.
Okay, so I have another one. Let me know if this is something you can do. It says, please repeat the IRS/RBI statute.
IRB.
Oh, IR. Oh, I'm sorry. IR. Yep, IRB.
Okay. All right. The regulations are in Internal Revenue Bulletin, IRB, 2015-27. So if you Google IRB 2015-27, then you're probably going to come up to the website. And if you want the website is www.irs.gov/IRB/2015-27. So it's in the Internal Revenue Bulletin. That the Internal Revenue Bulletin is issued once a week or very, very often during the year. And so the 2015 means that it was issued in 2015 and it was the 27th Internal Revenue Bulletin. So IRB 2015-27 will get you to something that has some other things in it, but if you look at the table of contents for the IRB, you'll see that there's a reference to the proposed regulation, and that's what they are. They're proposed.
So George, we have a follow-up to the question regarding rent. So it says, if the money used for rent is already counted as income for the person with a disability, would SSI still use that as countable income?
If it's already counted, no, it wouldn't be counted twice.
Okay. So that's the end of our questions that we had. That was a great webinar. We had some fantastic questions. It may take us up to a week to get this posted, but you will get a link to SurveyMonkey. You will get access to the entire PowerPoint to have all of George's information. And George, I believe you and I had chatted about possibly doing a follow-up, about a 30-minute follow-up in the future on this.
Right. One of the things that's is difficult to prepare a webinar for is to know that a lot of the questions that people have are the how and where and when, and I don't have the answers to how, when, or when, where or when. And I think that the end of this year, which we're coming upon pretty quickly, uh, will provide some practical guidance. So, Laura, I think that probably a half an hour of a discussion of the practical guidance that we learn at the end of this year. So I would suspect that probably in February or March we would have something. They should look on some of the websites for disability advocate groups uh, because a lot of them have people whose job it is to look at these regulations, and you can get maybe a preview of what's going to happen. The other thing is that it's probably going to be a bank or an Oppenheimer or something like that that's going to offer them. So there might be some advertisement that would apply to the ABLE accounts. So it's going to be less in the legal area and more in the disability rights area and in the area of companies that would be offering the ABLE accounts.
Okay. George, I actually had one more question come in, and they wanted to know where they might be able to find more information on Medicaid payback. They're a little confused by what that means, and it sounds like the money, that it would drain any money left in an account when the person dies. So,
That's correct. That's exactly correct. So don't count on the money that's in an ABLE account to go to anybody other than the state when the person dies. Because remember, it's for the Medicaid paid after the date the account is set up, but the account has a maximum of $14,000 a year that can go in there. So it's very easy to run up a big Medicaid bill, and then you're going to expect to pay the state. So the answer that I give to people when they talk about Medicaid payback is whatever you put in there and you don't spend is going to go to the state.
that's good information. Okay, I don't see any additional follow-up questions. Thank you so much, George, for being here with us today and doing this very informative webinar for us. And again, look for in the future, we're talking maybe February or March, a follow-up to more information on this. So thank you, everyone, for joining us today.